Hi, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney. And today we're going to talk about a pain and suffering damages verdict in New York for a trip and fall case. And this is interesting because what happens is if you go to trial and you get a jury verdict and you're not happy with the number because the number that you get is not appropriate for the serious injuries that you have, right? What you could do is you could appeal, and then the appellate division will sometimes increase the jury verdict, and that's what happened here. So this is actually a blog that I subscribe to from another attorney named John Hochfelder, and he writes a damages blog about damages and jury verdicts. Let's go into this particular case. So what happened here was that on October 4th of 2014, Elizabeth, who was 63 years old, was injured when she tripped and fell walking down the stairs at a subway station. It was actually in Queensboro Plaza. So she sued the transit authority and she claimed that she fell because of a missing piece of hardware on the final step. So I guess the final step was supposed to have a piece of hardware. That piece of hardware was missing, and there was like a hole or a missing necessary piece of the step itself, which is the riser, and then the tread. And so something was missing, and she fell. And so she went to trial, and the jury found that the defendant, the New York City Transit Authority, was 100% at fault. So then they had a damages trial. And in the damages trial, the jury awarded Elizabeth pain and suffering damages in the amount of $150,000. And this was all passed for the 5 years and 4 months. So from the date of the incident, October 14th, 2014, for 5 years, I guess in 2019 they had this trial 5 years later, and then it was 150. And so the plaintiff argued that the amount was inadequate, but the trial judge declined to change the jury's verdict. So what happened was then it went to the appellate court and the plaintiff appealed. And so in the case of Enriquez versus Metropolitan Transit Authority, it was the second department, 2025, the court found that the award was inadequate. And it said that it has to be increased from $150,000 all the way, they actually doubled it to $300,000. But they rejected the plaintiff's argument that the jury made an error in awarding nothing at all for future damages, future pain and suffering. So here are the injury details. The injury was a trimalleolar ankle fracture requiring 3 surgeries. The first was an emergency open reduction internal fixation surgery with plates and screws. The second was a surgery on March 13th, 2015 to remove some of the hardware that was being very painful. The third was on April 3rd, 2017 to remove the remaining painful hardware. And then the client was admitted to the hospital for a few days for each surgery and to rehabilitation facilities for 70 days until finally being discharged home on December 11th of 2014. She was visiting nurse home care for a year and a half. There were 105 in-home treatments. The plaintiff, Elizabeth, testified that she has continuing, constant, severe stiffness and pain, making it difficult to walk without assistance and requiring a home health aide for 4 hours a day, 5 days a week. So the defendants opposed any increase in the jury amount, and they argued that the plaintiff did not call a doctor to testify about Elizabeth's injuries or any future prognosis. And the plaintiff's attorney claimed that her treating surgeon notified her in the middle of trial that he would not be able to testify because he'd be out of the country. And the judge gave the jury a missing witness charge, and the plaintiff supported her claim for future pain and suffering damages with extensive medical records that were in evidence encompassing her surgeries and medical treatment thereafter. So in the closing argument, the plaintiff's attorney asked the jury to award $750,000 for past pain and suffering and $500,000 for future. And the defense counsel stated that the only evidence on damages was plaintiff's self-serving testimony, her own testimony, right? Because there was no doctor, I guess the medical records. And he asked the jury for no award of any damages. And there was no claim for future medical expenses or loss of earnings. The plaintiff was a retired school crossing guard. And during the liability trial, the defendants offered to settle the case for $247,500, and the plaintiff rejected that offer. Now, just from reading that, here's a few of my points of analysis. Number one, if you have a doctor that's going to testify for you, you got to make sure that doctor is going to be available when you have a trial date, right? You know when the trial date will be. You speak to the doctor. If the doctor is going to be out of the country, he doesn't go out of the country like on a day's notice. Then you tell the judge and you just coordinate the schedule. You get a few weeks for when he's back. You want to have the doctor testify. It could have been a completely different case. Second of all, this woman has tremendous injuries. I mean, trimalleolar fracture, all these surgeries, in-home care, rehab for 70 days. I mean, why not do like a little bit of a biography of her? I'm sure she has family, friends. I'm sure she has some passions. School crossing guard, that's like a great profession. She's helping children for her whole life. She's retired. Talk about that. Get some other crossing guards to come in. Talk about how she was before, how she is now. That would have changed the case. That could have been like a $2-3 million case. I don't understand, how that could have happened. That's almost like legal malpractice in my opinion, but that's just my opinion. So, but this looks like really, really serious damages. And so the fact that they went to the appellate court and they had to ask the appellate court for help, and the appellate court agreed and gave them $300 instead of $150 is of course good, but even $300 is not really much for this kind of injury. I mean, I settle some of these cases and we get sometimes like $850, sometimes like over $1 million. And this one is much more serious than the ones I'm talking about, where we've settled for over $1 million. So it's kind of like a very low result. And then the other thing is, like, why was there no claim for future medical expenses? I mean, of course, lost earnings she's not going to have because she's retired, but future medical expenses, all you have to do is ask a doctor or a life care planner or an economist to work together, talk about other things like physical therapy, prescriptions. She's only 63, right, when it happened. People live to be about, 83, 84. That's right in the pattern jury instruction averages. So you have 20 years. So what about the future 20 years? What about those medical costs? That could be huge. That could be, millions of dollars right there, or if not millions, maybe 800,000, 900,000. You have to get that itemized, and then the economist to reduce that to present value. But I'm seeing like she's already had all these surgeries. There could be additional surgeries. There could be physical therapy. There's need for, prescriptions, follow-up MRIs. This is not someone who's not going to need any medical care. As you get older, your medical care actually increases because you have more problems, like probably arthritis. So I just don't understand why they wouldn't make that claim. And then we could also turn to the actual appellate division decision. And in that decision, what they basically say is that the amount was inadequate. The jury verdict on the issue of damages on that 150 award, and zero for future pain and suffering. And they modified the jury decision on the facts. So they reviewed the facts, right? The evidence, the medical records, the plaintiff's testimony, in the exercise of their own discretion. And they deleted the 150, and they said you could do a new trial on the issue of damages, or you could basically take $300,000. A jury's determination with respect to awards for past and future pain and suffering will not be set aside unless the award deviates materially from what would be reasonable compensation. The reasonableness of compensation must be measured against relevant precedents of comparable cases. Under the circumstances of this case, where the plaintiff was required to undergo 3 surgeries as a result of the accident, the jury's award for past pain and suffering was inadequate. So the 150 is inadequate. And they cite some case law. And they say the jury's award of damages for future pain and suffering was not contrary to the weight of the evidence, because the plaintiff failed to provide any medical evidence of her current condition. Right, so if you don't show what your current condition is, if you don't have a doctor talking about future medical treatment and future, the doctor has to basically take the stand and say, I swear I'm a doctor to a reasonable degree of medical certainty. She's going to need future treatment. This is not going to go away. This condition is going to turn into arthritis, this and that, but he didn't have any of that. So then he said that's not contrary to the weight, of all the evidence. So it's fine to give 0 for the future. And that was basically the decision. So yeah, it's just like another kind of like caution tale that how you can, fix these cases. If you think a little bit earlier, don't take too many cases as a lawyer, spend your time, have somebody who's like a trial prep paralegal who's going to call and coordinate. Sometimes the trial lawyers get busy, but you have to have a staff that's going to call. If your doctor's out of the country, if they're out of the country like forever, if they moved somewhere else, then get another doctor to be an expert. Or if they're just out of the country temporarily, which is what this sounds like, just coordinate the schedule. But, and then what about future medicals? It's just a lot of things that could have been done to make this a much bigger case. But it is a good tale in that, 150 would have been ridiculous. At least it was doubled, and that you could apply to the appellate division. And they are conservative. You see, they didn't really increase it. They could have increased it to like 850 or 1.5. They didn't do that. They increased it to 300, which is still kind of low, but at least, it was better than the 150. So let us know what you think. Our goal is helping serious injury victims and families. We are here for you. Please like and subscribe to our channel, and all the best, everyone. Okay, bye-bye.